violate regional protocols like those of the East African Community. Key objectives to the bill. Key objections to the bill. 1. Threat to healthcare financing and health delivery. Uganda's health system, as mentioned above, depends significantly on international health financing and research grants. 2. Medical equipment and drug donations, critical for addressing stockouts, which is a big public cry in many facilities. 3. Training and technical assistance facilitated through global health leadership and regional protocols. All those are being threatened by this bill. 2. The bill's requirements for prior approval, registration, and vetting of foreign-linked funding. 1. It will delay procurements. 2. It might lead to suspension of donor funding. And 3. It might disrupt critical services such as HIV, TB, malaria immunization, primarily focusing on major international cooperation agencies. All these will be disrupted. 4.3. Criminalization of legitimate medical practice. The bill expresses medical professionals. The bill exposes medical professionals and institutions to crime. This is deeply troubling because, 1, there will be conflict in medical ethics. Professional ethics requires clinicians to prioritize patients' welfare and the do no harm principle above all. Forcing medical practitioners to wait for bureaucratic approval. The fear of severe criminal sanctions will discourage health professionals from engaging in legitimate international networks vital for responding to cross-border health threats like Ebola and COVID-19. 3. Brain drain and isolation, fellowships or collaborative research opportunities to avoid legal jeopardy. And this risks isolating Uganda from global scientific community. I decide to step and go to China, and I know that coming back is a problem. I might decide to remain there. Affecting Ugandan doctors who travel abroad for further studies, work, or medical practice and later return. They may be classified as foreigners, limiting them to temporary difference between life and death. Subjecting medical practitioners to the threat of imprisonment for a foreign agent poses a significant threat by 1. Capturing routine research partnerships. Many local health institutions, such as the Uganda Virus Research Institute, various universities, medical schools, operate through long-distance international grants. Many clinical trials and research projects funded by international donors have significantly contributed to the advancement of Uganda's health sector. Labeling these essential partners as foreign agents creates uncertainty, unnecessary stigma, and administrative hurdles. If you pick the document, I'm on page 10. Undermining institutional review processes. The proposed vetting layers risk bypassing or duplicating existing ethical oversight by the Uganda National Council of Science and Technology and the institutional review boards, leading to regulatory paralysis. Number 3, discouraging global clinical trials. By introducing discriminatory approval regimes, Uganda becomes a less attractive destination for global clinical trials. This deprives Ugandans of early access to cutting-edge treatments and vaccines for diseases like HIV, malaria, and Ebola. Number 4, long-term consequences. Weakening these structures will ultimately erode evidence-based policy, hinder pandemic readiness, and lose local talent. Risk to emergency and epidemic response. Public health emergencies require immediate and decisive action. Uganda's acclaimed response to outbreaks such as Ebola, Marburg, and COVID-19 have historically depended on 1, rapid cross-border cooperation, 2, immediate funding disbursement, 3, swift deployment of international expertise. These would be put in jeopardy. Fatal delays. Subjecting these critical responses to prior political or administrative approval processes may cause fatal delays. In the context of an epidemic, a delay of even a few days can lead to exponential spread. Health emergencies do not wait for regulatory clearance. Violation of constitutional and professional freedoms. The bill in its current state appears to infringe upon the fundamental rights enshrined in the Constitution of the Republic of Uganda, and specifically, freedom of profession, that is Article 40, freedom of association, Article 29, academic and scientific inquiry, and the right to health. Professional independence. Healthcare professionals must remain professionally independent and ethically neutral. Forcing clinicians to serve as extensions of state security or administrative vetting apparatuses undermines the scarce trust between the doctor and their patients, especially in sensitive humanitarian context. Allow me to skip and go to page 15, in the interest of time, Mr. Chair. Legal and constitutional framework. The concerns raised by the medical fraternity are firmly grounded in Uganda's constitution and existing health laws, which collectively impose positive obligations on the state to protect the health service, medical professionals, and the public health system. 1. Constitutional guarantees. Rights to health and state obligation. The Constitution of the Republic of Uganda places an affirmative duty on the state to safeguard the public health. 1. National objectives and directive principles of the state policy, objective number 14, and then objective number 20. Rights to life. Article 22(1) guarantees the right to life. Courts have consistently interpreted this right to include access to essential health care, especially where state action or inaction foreseeably leads to loss of life. Number 3, freedom of profession and association, Articles 29(1)(e) and Articles 42. Limitation of rights test, Article 43, and then potential amendments that may be required if this bill is enacted into an act. If enacted in its current form, the bill may necessitate constitutional amendments affecting Articles 1, 2, 5, 8A, 9, 10, 11, 12, and 14, Chapter 4, and then national objectives and directives, principles of the state policy, objectives 5, 14, 18, and 20. Allow me to skip to page 18, and I bring to light the implications for the Uganda Medical Association. The Uganda Medical Association risks 1, deregistration or criminal liability if the association receives or channels foreign funding for activities such as training grants, human rights advocacy, continuing professional development supported by international partners. It also risks self-censorship. The association may become reluctant to engage in policy advocacy, which is part of what we are doing, litigation, which we are also doing, public discourse on issues related to health financing, labor rights, and governance. We are going to censure ourselves and may retract from these activities, and maybe that's the intention of the law, of the bill. This fear of sanctions under the bill will undermine the association's constitutional mandate to protect the interests of the medical professionals and advocate for better health care for all Ugandans. Finally, Mr. Chair, recommendations. We respectively recommend that Parliament takes the following actions. 1, reject and or substantially amend the bill. 2, explicitly exempt essential health services. Explicitly exempt the following at a bare minimum: essential health services and financing, medical research, clinical trials, professional training, public health emergencies and epidemic responses, healthcare institutions, public, private PNFPs, and professional medical associations and councils. Number 3, we request that one of the recommendations, number 3, that we provide clear definitions, narrow definitions for terms like foreign agent, and we're not the first ones to mention this, sovereignty, and foreign funding. To avoid unintended inclusion of professionals and institutions receiving funding for legitimate public health, research, and development purposes. B, prevent arbitrary enforcement and legal ambiguity in the. Number 4, introduce proportionate regulatory threshold. Review and raise the financial threshold, currently put at 400 million, to align with sector realities. We are proposing that this should be raised to 5 billion Uganda shillings, particularly in health and research. And I'm glad the people from the Muslim society alluded the same. Number 5, remove criminal sanctions. Number 6, retain sector-specific oversight. Approval and oversight of funding in specialized sectors such as health should remain with technically competent bodies that include the Ministry of Health, National Drug Authority, Uganda National Council of Science and Technology, professional councils such as the Uganda Medical Dental Practitioners Council, the Nurses and Midwifery Council, etc. These bodies should retain authority rather than centralizing approval under security agencies that may lack sector expertise. Recommendation number 7, Chair, as I conclude, strengthen existing legal framework. Harmonize the bill with existing laws such as Anti-Money Laundering Act, CAP 118, Non-Government Organization Act, CAP 109, Public Health Act, CAP 281. This will avoid duplication, regulatory conflict, and overreach. Recommendation number 8, engage in meaningful consultation, and I'm glad you've given us the opportunity to air our views, so thank you very much. Finally, in conclusion, 1, we urge Parliament to recognize that medicine is not a political instrument. With rights to life, Article 22, delays caused by the clause, Article 22, delays caused by the clause number 6, approval regime, or clause 22, funding bottlenecks, will inevitably lead to loss of life during medical emergencies. Violation of Article 40, freedom of profession, restricting how licensed medical professionals practice based on their funding sources, is an unconstitutional limitation on professional practice. Failure of Article 43 test, the bill's vague definition, do not meet the legal standard of specificity required for criminal law and are not demonstrably justified. Number 3, will 1, harm patients and increase preventable morbidity and mortality. 2, weaken the health system and disrupt essential services. Number 3, endanger public health outcomes and emergency response capacity. Number 4, undermine progress towards universal health coverage. Number 5, isolate Uganda from global scientific and medical advancement. A sovereign nation is only as strong as the health and well-being of its citizens. Sovereignty is best protected by a healthy and productive population. Weakening the health system through this bill is actually a sovereignty risk, not a protection. You can clap. Therefore, for these reasons, the application of this bill to the medical fraternity is unconstitutional, disproportionate, and contrary to the public interest. We therefore respectfully call upon the Joint Committee of Defense and Internal Affairs and Legal and Parliamentary Affairs, the Parliamentary Committee, and the entire Parliament to oppose the bill in its current form, or substantially amend it to protect Uganda's medical profession and the health of all its people. Service with honor, Dr. Frank Ravinda Asimwe Nyamshoche Kanindeva, the President of Uganda Medical Association. I thank you.
Thank you, Mr. President. I wish to acknowledge how good and how well the lawyers have worked with the doctors to come up with a comprehensive it has been good. So can we have just one issue, because their document is quite clear, very clear. No question. Thank you so much. You stand discharged. Your matters are going to be given due attention when the committee is sitting. And do we have a doctor this side? Dr. Lulu